Hi, I'm George Staropoli. Welcome to another issue of Private Government Video News. Today I will be talking about justice for Arizona homeowners living in HOAs. I met with the Department of Fire, Building, and Life Safety Director, Barger, and his staff, Deputy Director John Stama, an attorney, Beth Solier and Deborah Blake, along with Assistant AG Camilla Alicon, for about 45 minutes this morning. In short, approval was withdrawn because of money shortages, and that Judge Downey had ruled that dfbls doesn't regulate HOAs. I am talking about the withdrawal of the appeal of the constitutionality decision that said Office of Administrative Hearings cannot hear HOA complaints. Furthermore, Mr. Barger believed that they, quote, would not win, quote, an appeal. The Assistant Attorney General added that the Attorney General cannot act independently and must be requested to act by the agency. A discussion followed regarding Judge Downey's bias that dfbls doesn't regulate HOAs. I countered with the fact that the two precedents used by Downey ignored other pertinent elements of these decisions. From her decision, quote, the legislature may have had valid policy reasons for devising a different system for resolving homeowner association disputes, but it appears that the Department of Fire, Building, and Life Safety is a mere figurehead or parking lot for those disputes, unquote. I also argued that justice was not done by Downey nor by the refusal to appeal the decision. There are ample grounds for an appeal since the Attorney General's office had already argued in favor of constitutionality. This was a question of justice for homeowners living in HOAs. 2. The Department is still hearing complaints. I repeat, the Department is still hearing complaints. And the Department will file a correction with the Arizona Republic article that told the public otherwise. No answer was given regarding the number of any constitutionality appeals by the CAI HOA attorneys based on the Downey decision. As for a return of fees to Mrs. Wagman and others, or the status of prior OAH decisions, any future confusion, there was no meaningful answer. What is what is, and what happened, happened. 3. With respect to the AG's office, I pointed out the repeated replies for help by homeowners to Terry Goddard, the AG, that resulted in a statement that he could do nothing and to get new legislation. Well, the OAH legislation exists now, and still the Attorney General will not assist homeowners in their quest for justice. I pointed out that the AG's webpage under Consumer Protection, including AG investigations to consumer misrepresentation and fraud with regard to real property, quote, merchandise may include any objects, wares, goods, commodities, intangibles, real estate, or services, unquote. Yet the AG does nothing in regard to HOA fraud or misrepresentation. I pointed out that the Real Estate Department has refused to enforce its own rules and regulations with respect to disclosing material information. Quote, R4-28-1101B. A licensee participating in a real estate transaction shall disclose in writing to all other parties any information the licensee possesses that materially or adversely affects the consideration to be paid by any party to the transaction. I guess losing your rights and being subject to kangaroo courts and having exorbitant foreclosures forced upon you is not a material concern in the eyes of the Arizona Real Estate Department. 4. The director and staff said that they would adopt a more homeowner-friendly website to help petitioners understand the process. That the question of fees was beyond its control in that it must be self-paying. I pointed out that the injustices of the current process and legislation and how CAI HOA attorneys were using it to deny homeowner justice. I asked DFBLS to do what it could to bring these inequities to the attention of the legislators within their agency restrictions. They said they are not against homeowners. Ladies and gentlemen, new legislation is needed to fix the weaknesses of the current Office of Administrative Hearings law. 1. Include the restatement third property servitudes that governs HOAs in addition to Title 33. Clarify the priority of Title 33, the Homeowner Association condo laws, over Title 10, corporation law, in areas where they conflict. Adopt last year's SB 1162 with its restrictions to level the litigation playing field. 4. Homeowner associations should be made accountable for the monies, as are real estate firms and escrow companies, with state agency record keeping and reporting requirements and with surprise state audits. 5. Enforceable laws against violations of the governing documents and state laws by HOA boards, with meaningful fines and disbarment of offending directors. When the members must fork up assessments to pay for board wrongdoing, then they will take charge of their HOAs. There are other reforms to be made. These are essential. Write your legislature today. It is up to you. Thank you.
Disturb the sound of silence.